Right, we're back in Senate Judiciary in part 11. We are picking up S87, bill related to extradition. This is another component of the governor's omnibus bill, and we have led counsel to walk through.
Good morning. So for the record, Michelle Childs, Office of Legislative Counsel on the team of S87 as introduced. So I'm going to be really brief in my comments. I don't have really, other than working on the shield provision that you guys did a couple of years ago. This committee hasn't really worked in the 26 plus years I've been here on extradition issues. But you do have the experts in the room who do work on that. So in the governor's office as well as the attorney general's office. And I think they can talk to you about really what translates from some pretty archaic language that's currently in statute.
Michelle.
Yeah.
I can't really follow it. Just a conversation.
So if you look at the statutes and what we have in Title 13 with regard to extradition, and I had hoped to have a little more time to do some legislative history, but I think Vermont adopted the Uniform Criminal Extradition Act in 1933. There have been very few changes since that time. I'm sure probably the witness is going to talk to you a little bit about probably the frustration of trying to work with that existing language. But just as to kind of set the stage for you, there's three things that you want to think about when we're talking about extradition. So there is a provision in the U.S. Constitution, the extradition clause, and it requires states upon demand of another state to deliver a fugitive from justice. And we're talking about fugitives, we mean that somebody who has allegedly committed a crime in one state and fled to another jurisdiction. And it requires the states to, if that person is alleged to have committed treason, felony, or another crime, to deliver the fugitive back to the demanding state. So you have that in the U.S. Constitution. You also have a federal statute, and that federal statute kind of sets forth the basic process for which the states are to be delivering a fugitive back to the demanding state. And then the third layer on that is what we're talking about today, which is the Uniform Criminal Extradition Act. And it's been adopted by the majority of the states. And that kind of gets a little more into the granular detail of the guidelines of all the paperwork that has to go back and forth between the states. The process on the demanding state versus the state, the receiving state, and how they're going to return the person back to the demanding state. So there's a few changes in this bill that's before you. These provisions were proposed by the administration and the administration's omnibus safety bill. I don't think it has been introduced yet in the Senate, but there is a version in the House, so the language has been out there. And there are three primary sections. Section 1. You'll see the language starting on line 14 on page 1. If upon examination it appears that the person held is the person charged, so like when I think the AG's office is going to take you through the process and the things that are required around clear identification of the person and the finding that the person has allegedly committed a crime in the demanding state. So if you found those things and that the person probably committed the crime, there's a process now for holding that person. And you'll see that on line 19, it's 30 days. That's being extended to 120 days. And I think the witnesses can talk to you about why they need to extend an amount of time to be completing the process. Page.
Sorry, Michelle, is 4946 the shield laws that we passed last year?
No, that is a reference to something that was already an existing law, which is when the person is not in the demanding state at the time of commission of the crime. And there's some language, but it's somewhat related, but we created a new provision in there. And I can send you that reference. Okay, thank you. Mm-hmm. So section 2, and this has to do with someone who is arrested in Vermont, and they have escaped from confinement or broken the terms of their bail probation, and they can waive extradition. There's a new section that's added on page 3, having to do with people who are under supervision in another state. So they're under probation, parole, bail. And as a condition of that, that they have signed a waiver essentially to be extradited if they leave the jurisdiction. So you'll see there in the language in subsection C, a law enforcement agency in this state holding a person who's alleged to have broken the terms of a person's probation, parole, bail, or any other release in the demanding state shall immediately deliver that person to the duly authorized agent of the demanding state without the requirement of a governor's warrant if all of the following apply. So you see subdivision 1 is that person is prior to that moment has signed a waiver of extradition as a term of their probation or parole agreement or in terms of bail. Page 4, subdivision 2, law enforcement agency that's holding the person has received an authenticated copy of the prior waiver that that person signed. And subdivision 3 is that except as the state's attorney might decide, otherwise, all open criminal charges in the state have been disposed of through trial and sentencing. So if they're charged in this state with something, then it would have to be the state's attorney would be determining whether or not they could be extradited without the warrant based on the waiver if they have pending charges here.
So
How does this work if the person in this state has allegedly committed a crime in the demanding state that is not a crime in this state?
I don't think that matters.
Okay.
But I would turn that, I would ask the witnesses that. I
Okay.
don't know.
No problem. No problem.
So if someone has allegedly committed a crime, maybe it would be easier if I use it for an example. Someone has gotten an abortion in Texas and comes to Vermont, and Texas is demanding that we extradite them back to Texas. But abortion is not illegal in Vermont. Not that it is presently illegal in Texas for all abortions. That's what I'm sort of wondering is how does this work if the person is in this state where that is not a crime being demanded in a state where that is?
that becomes
Doesn't it?
the 14th Amendment issue. And whether or not that person has waived their right to expedition in the demanding state. But I think, I mean, the witnesses were probably some clarity on that one.
Yeah, and I don't think abortion is the only thing, but as we're thinking of things, I certainly worry about how things can interplay as some states are cracking down on civil liberties and I just don't know how much we want to. Yeah, that is all.
There are bases for being able to use it, but it's usually things like, so the person, they haven't been, they either weren't in the state at the time of the commission of the crime. Maybe they didn't receive full due process. The paperwork hasn't been transmitted, things like that. But I don't know the witnesses may about whether or not just because Vermont's law is different from another state's, but I don't think that we have the ability to deny that conditions to everything else is in order. So section 3, this is on hearing. So you've seen subsection B. If the judge here determines that the arrest was lawful, then they are to commit the person to be arrested and wait for the extradition warrant from the governor. And the 120 days is linking to the 120 days in section 1. You'll see there's a provision under existing law that the person would be possibly eligible for bail pending while they're waiting for that warrant. And you'll see the language on lines 18 and 21 that the judge is to consider the issuance of a judicial warrant for the arrest of the person who's fled from the demanding state to Vermont. And just to take that into consideration when they're looking at the bail issue about determining risk of flight from prosecution. And that's it. It's effective on passage.
Thank you. Committee, any questions for ledge council? Next up, we have Tim McManus from the State Attorney's Office.
Good morning, committee. Nice to see you all. My name is Kim McManus. I'm with the Department of State's Attorney and Sheriffs. Thank you for having us in on the S87. The Department of State's Attorneys and Sheriffs handles the majority of extradition cases for the state. In 2024, we were involved in 50 extradition cases. Our involvement as a department is on both sides of our shop, so to speak. Our prosecutors are litigating cases in court. Our sheriffs are transporting or coordinating the transport with their state or federal counterparts to move individuals into or out of the state. And our central office is assisting in the coordination of the paperwork and resources required to comply with the extradition warrants. As ledge counsel just noted, the statutes are quite old and complicated, and we very much appreciate the governor's office focusing on improving sections of the statute. And we saw the governor's recommended the very surgical strike to take care of some specific issues. We as a department did not see this as an opportunity right now, sort of blow up the whole section and do any major rewrites. So we are not presenting any testimony about other issues that we have within the statute. We do note some issues, and internally we are speaking about that. And this bill has inspired a lot of conversation in our department, but we want to bring any of those issues to you with solutions, which we don't have right now. So our comments today are very specific to the suggested changes in S87. We as a department support S87 as it's currently written. Just to run through the specific sections. Section 1, enlarging the time frame. We very much appreciate the administrative load that these warrants take. By moving it from 30 to 120 days, that makes absolute sense from our perspective. And we as well appreciate that extended amount of time. There's a tremendous amount of back and forth that goes on to get these warrants completed. And we appreciate as the Ledge Council has gone through and cleaned up just language as appropriate, we have an issue with any of the changes in section 1. For section 2, again, there's a lot of language just cleaning up sentence structure and gender notation, and we support all of that. The new language in section B, or excuse me, in section C, 4967 on page 3, expediting the process if a person is alleged to have broken the terms of probation, parole, and bail, or any other release without requiring the governor's warrant. We again support this. We appreciate anything to simplify the process. We appreciate. We would, however, defer to general counsel from the governor's office or the attorney general's office to just note whether any of these changes have any issues with our interstate compacts. We do not think they do, but we did not do a deep dive on that. And the attorney general's office advises the governor's office on extradition matters, as does the governor's general counsel. And so we would absolutely defer to their opinion on that.
Yeah, if I could interrupt real quick, I wanted to just clarify for the committee when we're looking at page 4, line 2, we're talking about an authenticated copy prior waiver. Are we talking about a document that has been been stamped by a court clerk saying this is the actual copy of the waiver of extradition versus a copy that anybody could pull off of Odyssey, the online database, and just potentially modify or anything like that. I just want to make sure that we're clear that this is something that is done by a court, the authenticated copy.
Yes, I mean, as I read this, this would be a certified authenticated copy. And so you've likely seen that where the court staff will stamp the document with that language and then sign and date it. And then again, it's maybe emailed or faxed, but it has that, it's not to be mailed, the physical copy, but it has that certification on it.
Okay.
Yes. And then sorry, and then just last, section 3, again, the language that's cleaning up, or sorry, amending reasonable time to within 120 days. We support that. We appreciate the clarity of it. And we also appreciate the clarity given to the judiciary to consider the out-of-state judicial warrant when considering the flights and prosecution risk when considering bail conditions. So we have no issue with those additions.
I wanted to just briefly talk about section 3, page 4, line 5. What I'm envisioning in hypothetical situations, if somebody is wanted for a homicide in another state, but they get arrested for a petty larceny here in Vermont, and the state's attorney is saying, yeah, we should probably send them over to the other state where they committed the homicide because that is far more serious, the petty larceny. But in other situations where it might be a robbery in one state and a robbery in Vermont, Vermont would presumably want to resolve its case first and then follow up by sending them to the other state. Is that the ballpark of what that section is getting at?
Yes, and again, that section, right, is very specific to these issues when somebody is violated, when the extradition to the other state is based on probation, parole, bail, or other issue, that yes, the state's attorney would have that discretion, and more than likely, if we have open cases, and it's again a probation or bail issue in another state, we would want to resolve our issues first. But the language there allows, if there was an interest of justice that prevailed and we wish to send them over, that the state's attorney could make that call.
Okay.
Yes.
Thank you. Anything further?
No, that again, we did not want to open Pandora's box on this. It was very specific, the amendments that were suggested, and we support the amendments as written.
Committee, any questions or comments? Okay. Great, thank you.
Thank you so much.
All right, next up we have Todd from the Attorney General's office.
Hello again. Todd Davis from the AG's office. I'm going to take a minute. I also want to introduce Sophie Stratton, who's another Assistant Attorney General and handles the extraditions for our office, working together with the Governor's Council. I want to give just a quick background, and let me check in with you first, Chair. What I have in my testimony walks through kind of the current burden that the extradition process creates, and what we feel is that the changes recommended here will cut a good portion of that burden, easing some of the challenges for prosecutors, judges, and frankly, closing time to getting people back to face justice wherever.
I think it would be helpful to hear from your perspective what problems this is trying to fix.
So broadly, just at the outset, before I get into that, we do support this language change with one slight tweak. We'd like to see that we could at least pass on the Ledge Council. I'll talk through that as well. It's mostly related to the fact that Vermont has one carceral system, the Department of Corrections, and we want them to work to streamline these there. So as Ledge Council laid out, extradition exists in the Constitution, federal law, and state law, hasn't been updated for a while. And the way the process currently works is that the only waiver, and that's really what this focuses on, is a waiver of a formal extradition process, recognized in Vermont are those signed by a fugitive before a judge on the record in writing following an advisement of rights. Our office's understanding is that S87 seeks to codify the acceptance of a prior signed waiver of extradition to expedite extradition proceedings, which consume time and resources from all parties in the criminal justice system, both in the demanding and the holding or asylum state. In this instance, we're talking about Vermont as the state that's holding the individual, including law enforcement, prosecutors, defense counsel, courts, and the government. In many states, when a defendant with a pending case is ordered to conditions of release, or when an offender is placed on probation, furlough, or parole, they sign a waiver of extradition stating that if they flee the state in violation of their conditions of probation or parole, they have waived the formal extradition requirements of the Uniform Criminal Extradition Act and may be immediately returned to the demanding state. I would just add, that's essentially saying in the same way that when you're released on conditions and stay within the state, if you violate those conditions, you recognize that you potentially face further criminal charges based on that violation. Vermont currently does not recognize these pre-signed waivers of extradition signed by a fugitive in the demanding state, but doing so, which this bill would accomplish, would create more efficiency and timely extradition of fugitives from Vermont, far more concisely than our current formal extradition proceedings. So I'll walk into that now. When a fugitive flees from justice, the prosecuting agency enters a warrant for their arrest in the National Crime Information Center, NCIC database. NCIC is a computerized index of missing persons and criminal information. I think the committee has some familiarity with this. With fugitive and arrest warrant information available to law enforcement nationwide. When a fugitive is arrested in Vermont, law enforcement contacts the issuing agency in the demanding state to confirm that the warrant is active and extraditable. They take the fugitive into custody, confirm their identity, and prepare the required documentation for a fugitive complaint to be filed in Vermont. And the documentation, which was a piece of the question you asked before, is information from NCIC stating the fugitive is wanted, and the issuing agency, the agency that said they're now wanted in a requesting state, an affidavit from the Vermont law enforcement with the circumstances of the arrest and identification of the individual, the underlying charge or conviction, and the basis for the warrant in the demanding state and its maximum sentence. And that's important because if it isn't punishable by up to a year, extradition, as I understand it, is not a possibility. So it's somewhat more serious crimes. Though certainly some misdemeanors will fall into that category. And then finally, documentation from the demanding state, including the charging documents, judgments of conviction, and conditions of probation or parole, law enforcement affidavits, the active arrest warrant, and identification such as photographs, fingerprints, or an affidavit by law enforcement in the demanding state. So there's a lot of pieces to what it takes to extradite someone. The documentation, that whole package, is then provided to the state's attorney where the arrest took place. The state's attorney then prepares a complaint and a petition for interstate rendition of the fugitive. The complaint and supporting documentation are filed with the court, which generates a fugitive case. The fugitive is then brought before the court, arraigned on the petition that has been prepared by the state's attorney, and then the fugitive decides whether to voluntarily waive extradition under the existing law. If they waive, they're promptly extradited. If not, bail is then set unless the offense they're charged with in the demanding state is punishable by life imprisonment, and then the fugitive case continues pending issuance of a governor's warrant. Does that all make sense so far? It's a lot of different steps and a lot of different permutations, but this is just how the existing process has to operate. So at this point, the state's attorney notifies the prosecution in the demanding state where the individual has fled of the fugitive's refusal to waive extradition. The prosecutor in the demanding state then prepares a requisition request, which is typically sent to the state's Department of Justice or Attorney General's office for review in the demanding state. In Vermont, after review, the requisition request is then sent to the demanding state's governor. So again, this is all happening in the other state. In Vermont, pursuant to another piece of the statute here, 4944 and Title 13, the request is then sent to the Vermont AGO Criminal Division, where it's reviewed to ensure it meets the legal requirements set forth in the law. And if the request is sufficient, it is sent to the governor's office for further review and issuance of the governor's warrant. That's just how it gets here. The governor's warrant is then sent to the sheriff for service where the fugitive is incarcerated or living if they're on bail. On service of the governor's warrant, the fugitive is then again brought before the court to be advised of the demand for their surrender, the crime they are charged with in the demanding state, their right to counsel, and to allow reasonable time for the fugitive to apply for a writ of habeas corpus. So unless a writ is filed,
Todd, can you clarify for everybody, what is a writ of habeas corpus?
So it dates back to, going to strain my legal recollection here, but it dates back to common law in England. And it's essentially a way of making the government prove why it is appropriate to be holding incarcerated. So essentially proof of probable cause is generally sufficient. But it's a very important legal act. So after all that, the fugitive is surrendered to the demanding state. Many states have statutes like this proposed bill, allowing extradition by law enforcement or corrections upon receipt of the prior waivers of extradition, which are frequently signed by individuals in order to be released on probation. California provides for a de minimis hearing before the court, find probable cause that the fugitive signed a waiver. Other state courts have interpreted extradition statutes to allow extradition without a governor's warrant based on pre-signed waivers. The National Organization of Extradition Officials, the National Association, so they're called, adopted a resolution recommending that all states adopt legislation recognizing pre-signed waivers of extradition in recognition of the immense resources required in that entire long series of steps that I just walked through for formal extradition proceedings, as opposed to the efficiency of recognizing pre-signed waivers. So based on our review of the statute as it stands, we support the language included here. We support both the extension of time and the process that will allow the recognition of pre-signed waivers. In Vermont, at least half the requisition requests are reviewed by the AGO, and of the ones, sorry, I misspoke. In Vermont, at least half the requests the AGO reviews contain pre-signed waivers of extradition, and updating this statute should enhance the efficiency and timeliness of the requests. The one thing we would recommend, and I apologize, I don't have my printed copy of S87, so I don't have the line number here, but it's in 4967, thank you, Jay. It's on page 3, line 13. Notwithstanding any other provision of law, a law enforcement, and we would add the words or corrections there, agency.
Oh, you have it.
Jay, just one thing. But essentially, because so many of these individuals, we don't have local jails, we don't have county and incarcerated systems, we have a statewide system. We think it's important that DOC has the opportunity to act on these kinds of pre-signed waivers because of the efficiency that will add, as opposed to, even with the language as it is, we think there would still be multiple steps to get a pre-signed waiver if only law enforcement had that. So by adding corrections, it allows corrections then to confirm that there is a pre-signed waiver and that it's authentic, to confirm the identity of the individual who's held in Vermont and is the same as the individual who's charged with a crime and signed a free waiver in the requesting state. That's essentially the edit we think is important. It's changed, as I say, on line 813 on page 3, and a similar change to line 1 on page 4, again adding or corrections after the words law enforcement. I think just in conclusion, as I said, those changes would address the unique aspect of Vermont's criminal justice system because we don't have local jails. The inclusion of corrections in the proposed bill would allow DOC to lodge fugitives, verify pre-signed waivers, and ascertain identification. This would ensure consistency and uniformity throughout the state while alleviating the piecemeal burden of local law enforcement agencies. This inclusion would also clarify that fugitives may be held by DOC pending verification of identity and pre-signed waivers resolving any ambiguity. So in conclusion, we support the language in S87, believing that it promotes efficiency in expedition proceedings while addressing an unnecessary burden.
I just want to understand, under current law, these types of extraditions are only happening for crimes with penalty of a year or more.
I believe that.
And that is legal and constitutional in line with, so we can limit.
Assuming that, yeah, I want to be a little careful how deep, because I heard your question and was talking about it, and Sophia, welcome if you want to add anything to this, but essentially, I think what Senator Sheen was looking for is the concept of comity, right? That states honor each other's laws and respects the law enforcement elements therein. I believe that the way extradition works is if it is it has to be a significant crime, and that line of demarcation is that it's punishable by up to a year.
And that's in the federal statute.
I believe so, but we can check on that.
It's in our state statute, our uniform criminal extradition act.
So it's in the Uniform Criminal Extradition. I'm just repeating because I'm not sure. It's in the Uniform Act that Vermont's adopted.
Okay, and I certainly appreciate the desire to honor each other's laws, and in the point in time we're at, there are laws that are coming forward that are frankly barbaric, and I don't know that we want to be in the habit of honoring that.
Understood.
So if there's ways in which we can tighten up the limitations, that would make me feel a lot more comfortable.
Yeah, I do agree. I think in terms of comedy, that was the word I was trying to find when I bring it, but for the most part, and correct me if I'm wrong, but my understanding was that we generally have to respect other states' laws. Meaning to the 14th Amendment. Yeah, I don't know what, I can't remember the nuances and the carve outs of it right now, but can you speak more to that, or should that perhaps be a conversation for another time?
I think we'll be better off if I have a moment to think more about it.
Thank you. So, any senators?
I don't know who to ask this question. I've got a bunch of knowledgeable people here in front of me. So, as we all know, the judicial justice warrant or affidavit is back. The officer has to deal with once we get back to the office. What does this do to expedite that process or alleviate certain things from the arresting officer, we'll call him, or just due to the fact that they've taken him into custody? And just walk me through the scenario that if in fact I stop someone for a civil violation like speeding, run a records check, 27, they come back, execute a warrant out of whatever state they want to choose. We all know that it's not going to be a charging affidavit with that. And the process in itself is to get that information from many smaller agencies out of state. When the courts are closed, whatever else is just, and our correction system generally don't want to take people out an affidavit from an officer showing that all these certain things. How does this alleviate or expedite the process for the officer? So
I'm going to defer a specific answer to that to Sophie, if she has it.
Sure. So I think the burden that this alleviates on law enforcement in the short term is the reason that we want corrections added is because most local law enforcement agencies in Vermont don't have the ability to lodge people indefinitely. And then there's only limited circumstances that corrections can take people into custody and hold them without a court issuing a minimus. So some of those are in the interstate agreement on detainers or supervision of people on probation from other states. But what this would do in the short term for law enforcement is essentially they could gather some preliminary documentation for identification and ascertain whether there's a pre-signed waiver, then lodge that person with corrections, and then the law enforcement officer would not have to put together a fugitive petition for the state's attorneys. There would be a reasonable time that that person would be lodged either by local law enforcement or DOC for them to receive the authenticated documentation and the pre-signed waiver. And then by the time that you get to someone being arrested and then lodged, there have been a lot of steps to affirmatively identify that person. And I believe now all DOC facilities has what's called live scan. So it's digital fingerprinting that will confirm with DOC that the person they have in custody is the person who was arrested on the fugitive warrant. Because here we're only talking about people who have already been arrested in the demanding state and have been brought before court. So usually if they're in NCIC, they've already been booked somewhere, so their fingerprints are on it. So that would alleviate the burden on law enforcement. to generate a fugitive petition, which usually, like when someone's arrested for a crime, happens on a pretty short time frame for the officer to gather all the information, because the statute requires that that person arrested on a fugitive warrant is brought before the court forthwith. And then the state's attorney can request up to 3 days to verify all the information in the fugitive petition if they feel like they need to. But then this kind of circumvents all of that if there's a pre-signed waiver. And actually, a lot of issuing agencies will put in the NCIC want information whether there's a pre-signed waiver. There's a way for them to do that, so that information is readily available to law enforcement.
So they'll be able to just put together a short affidavit, have a copy of pre-signed extradition and lodge them just on that until.
I don't think they would even need an affidavit. I think it would just be NCIC affirmative, like due diligence on identification, and then requesting the documentation from the demanding state that we have the right person in custody, the warrant is still active, it's extraditable, and then waiting for the demanding state to send an authenticated copy of the pre-signed waiver.
Well, I'm sure the law enforcement appreciate that. Thank you.
Anything for
Nothing for me other than I will follow up.
committee, anything further for Tom? Okay, thank you. Next up, we have Jay.
Good morning. Thank you for having me again. Jay Cushing Johnson and Governor's Council. Thank you for taking this bill up. I appreciate it. I wasn't quite sure what would be covered before me, so I don't want to duplicate information you've already heard. A couple of points I do want to make about the federal constitutional provision. It is a mandatory clause. So a person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed from the state having jurisdiction of the crime. So our Vermont Supreme Court has considered extraditions and has cited to U.S. Supreme Court case law, recognizing that this extradition clause articulates in mandatory language the concepts of comity and full faith and credit. And its purpose is to bring criminal offenders to justice in the states where they have offended as quickly as possible. So that's the purpose of the extradition clause. Really, it's to respect sort of the co-equal sovereigns who, of the 50 states. So we've covered state law to a certain extent. And also, as you've heard, the extradition process involves governor's requisition and issuance of governor's warrant. So this is both the extradition of fugitives from Vermont, so sending out, and the extradition of fugitives from other jurisdictions back to Vermont. So there are the two kinds that work. In this particular case, we're just working on sending back. So I wanted to emphasize, because I know there are some concerns about due process protections and the process as it exists. And I think this has been covered to a certain extent, but a person will have to be arrested and charged or convicted and released on probation. This requires, in the case of arrests, a finding of probable cause and an arraignment before a judge. They will require a voluntary written agreement that the two conditions of release, which include a waiver of the right to an extradition. It will require a failure to appear in court for proceedings in a state where the crime was allegedly committed. And the issuance of a bench warrant by courts for the arrest of the fugitive. And Todd went into the whole process and the administrative process that happens at that point. So I have a recent example, actually, and Sophie is the person who I work with in the AG's office, was the person who originally suggested there's a gap in the law in this area. So I want to thank her for that. But so we had a recent request from the governor of New Hampshire to bring an individual back from Vermont as a fugitive from justice. He had been convicted of felony forgery in July 2022. And I have to say, I have not seen an extradition request for anything other than a felony. Again, because it is such a burdensome process. Other states have the same kinds of issues we do, with respect to backlogs and burden on state's attorneys and sheriffs and police. I mean, so usually it is a felony. I guess to the senator's point, it could be a felony in another state, a 1-year crime, which is not a felony in Vermont, but is likely a crime in Vermont. So anyway, he was convicted of felony forgery in July of 2022. He was given a deferred sentence, so released on the deferred sentence, and was due back in court for a hearing on the deferred sentence in July 16, 2024. So 2 years later. He failed to show for the hearing, and a bench warrant was issued for his arrest. This is all in New Hampshire. Something must have happened. Either he contacted the court through his lawyer, or he was arrested. But he somehow was in court, because at that point, he waived extradition on July 29, 2024. Shortly after he failed to show for his hearing. This waiver was a condition of release in New Hampshire. And another hearing was scheduled for September 27, 2024. So obviously they have the same kinds of issues we do with court backlog. So 2-3 months later, he failed to appear for that hearing. A second bench warrant was issued and hearing was rescheduled for November 21, 2024. He again failed to appear, and a third bench warrant was issued November 2022. At that point, he was arrested in Vermont on the warrant in December of 2024. He refused to waive extradition, and at this time is being held on $25,000 bail in Southern State Correctional Facility. A status conference was held last Friday, and the judge granted a 30-day extension, knowing that the extradition request was coming to the governor. So this is in December. January, so this is a little bit of a view into it's my view anyway, into the process. January 15, the Grafton County Sheriff delivered the required supporting materials to the Grafton County, county attorney in New Hampshire. January 17th, the Grafton County attorney had completed the application to the New Hampshire governor. And on February 12th, the governor's requisition came to the governor of Vermont. So this is a month later, really almost 2 months from the date that the person was arrested in Vermont. February 28th was the date that the memo from the AG's office following their review came to me. That was a Friday, last Friday. We typically turn around a warrant. Sorry, it would have been Friday before. We try to turn around a warrant in 24 to 48 hours. Depends on the governor's availability, but we try and turn this around so that they don't sit. So that is really 3 months from the date that he was arrested in Vermont, and not just the date that he failed to show the third time for his proceedings in New Hampshire. So paperwork, but I just also wanted to read the waiver of extradition. The chair asked a good question, which is, what is the authentication process? I don't have a stamped authenticated waiver here, but it could be in the paperwork in the extradition request. I will go back and take a look for that. But basically, it's a very simple waiver, very clear. It says, I am the defendant. I wish to waive my rights to formal extradition proceedings. If I am in another state, the state of New Hampshire may make a formal demand for my return to New Hampshire to face the above charges. A governor's warrant would be issued and served on me, and after an extradition hearing, I could be removed. I could be returned to New Hampshire. I voluntarily, knowingly, and intelligently waive my rights to a governor's warrant and a formal hearing if I am in another state. And then in all caps, I consent to return voluntarily and without hearing or other formality to New Hampshire to face the above charges. And then that person signs the waiver. It's witnessed and dated. So there is a pretty clear, at least anyway, in New Hampshire, written agreement to waive the right to a formal extradition. So again, as was mentioned, our laws don't recognize the waiver at this time. And each time an offender from another state flees trial court proceedings for a crime committed in that state by traveling to or remaining in Vermont, because sometimes people commit crimes in New Hampshire, they actually live in Vermont. So they come back to Vermont, pending their trial. Sometimes they just don't show up back in New Hampshire. So they travel to or remain in Vermont. Once they're arrested in Vermont on the bench warrant, they have the choice of waive, contesting the extradition, habeas corpus proceeding. If they do not waive the extradition, they can't be picked up without a governor's warrant. So again, going through that entire process involving all of that, the agencies, the courts, the governor's office, the AG's office. And this time, this particular example is 3 months to return the fugitive. So while this person is an example, and the reason that we have sort of asked for the clarity language for direction to the court is this person is an example of a non-violent felon, but also quite clearly a flight risk and is being held at this time on substantial bail. So I think that this process actually also facilitates proceedings for the defendant who may be held in a Vermont facility for significant period of time while this process plays out.
Yeah, sorry to interrupt.
Yeah.
Wanted to let you know that we do have about 2 minutes left, so.
That's it. I'm done.
Well, thank you for your time. Committee, any brief questions? All right, well, we can pause there and revisit this hopefully before the last one. Thank you.